Hello students, in this video we are going to do about the topic independence of judiciary from the control of executive and legislative. Now, how is judiciary in the Supreme Court, how is judiciary kept separate from the executive and the legislative? We are going to do that in points. That means different things done in judiciary where legislative and executive do not have any particular say on that. So the first point is appointment of judges. So as I read, you also go through your books and see where we are reading so that you can understand it in a better way. Appointment of judges. Every judge of the Supreme Court is appointed by the President after the consultation of the Cabinet, as well as the judges of Supreme Court and High Court. So it is not the Cabinet who is going to decide, it is just they are consulted, but mainly the decision rests in the hand of the judges of Supreme Court and the High Court, so that the legislatives or the executives, they do not determine the people who is going to be the judge and who is not going to be the judge. Otherwise people might be flattering them, or maybe they might have their own people and they might twist the things and the judiciary might become biased. Although we are saying this is very hypothetical, but usually it is considered that the judges are always without any influence of the executives and the legislatives. On paper we can say it is given this ways, but we know the reality that they do get influenced, but that is as unethical. That is not accepted by the constitution or by the ways through which the people should be working. So second point is removal of the judges. It is not the president, prime minister, or the cabinet, or any of the executive, any of the legislative. They might feel and they might throw away any judge from the work. Besides that, the working of judge is not even questionable and he is not even answerable in the Lok Sabha parliament anyway. But coming to this point, we can see the judges cannot be removed from office by any authority. A judge can be removed by president only for proved misbehavior. Otherwise, for no other reason can he be removed from the office. This charge needs to be proved. If he has been considered that a charge that he has misbehaved or disrespected the constitution, even that also has to be proved by 2/3 majorities, and only then he can be removed. Otherwise he cannot be removed. Just that chief justice thinks, or the other people think that he should be removed, then only he can, and instantly they remove him. That is not the procedure. The procedure is longer and it requires a proper majority voting or majority acceptance of for the same accusation, and then only he will be removed. Third point, we see security of tenure. A judge can remain in office till the age of 65 years. That means even if he has a particular tenure of 5 years, 6 years, 7 years, basically there is not, even then also he could have worked it even longer after that till the age of 65 years. Or otherwise we can say, even if he has a tenure of, say, supposedly 5 years, then also he will not be able to work full 5 years, because he has got his age 65 years completing in the very second year or third year. So in that case he will have to resign, or he will retire, not resign, but he will retire. But here we do not see that particular thing. Security of tenure is 65 years he is going to work. Till the age of 65 years he is going to work. Nobody can remove him from this particular job, and that is the security which has been given to him. It is not that if he doesn't prove properly he will be asked to resign or he has to leave. Nothing as such. For any other reason he might be punished, he might be sent from one court to another court or something maybe, but nobody can remove or terminate his job. Security of salaries and services is another condition where the government, the legislatives, executives do not hinder the salaries, or cannot do any such thing, because the salaries and allowances of the judges are not at any particular disadvantage even during an emergency until the time they are in the term of office, because their salaries are taken from the contingency fund, consolidated fund, and that is even in an emergency also they are going to get their salaries without any particular changes. If they require, but you can say these people, they themselves decide that we want a deduction, say like this pandemic. So in some such conditions, similar conditions, they might opt for a particular deduction for some or the other important reason, for vital requirement of the country. But otherwise country is not going to remove, the government cannot change their salaries. Next, we see freedom to announce decisions and decrees. It is considered that they are free from the government control of legislative and the executives, and that is why they are free to give any decision they want to. Obviously, we see we have a lot of corruption and bureaucracy, because of which people have their particular decisions, you can say, fabricated or otherwise changed because of the fear or because of the money thing. But we can say that ethically it is so that they are supposed to be fearlessly giving their decisions, even about against any particular designatory also, because they are given proper powers to pass on their judgment against anyone. That is, only the fair judgment can be passed on when it is passed without any bias for each and every citizen of India. Next, we see punishment for contempt of court. The Supreme Court can punish for the contempt of court if a person or authority makes an attempt to lower the authority of the court or the constitution. So it is the Supreme Court who is going to decide that how and why they should be punished, and accordingly they can pass the punishments. Next is full control over its procedure of work and establishment. So the Supreme Court is free to decide its own procedure, how they are going to work, how and which people are going to be recruited, and what will be the condition of the work. All that is decided by the judges, by the court, and it is nothing to be decided by the government, by the parliament. So the legislative and the executives are totally away from their working procedures, the way they are going to work. Whatever they are going to do is only going to remain in the Department of Judiciary. Legislative and executive are not going to have any particular relationship with that thing. Here we can say that legislative are very deeply connected to the executives, but having a very close relationship between executive and legislative, still judiciary is totally apart from them, totally aloof and segregated and separated, so that it is not hindered by, or the decision or the judgment is not hindered by any such powerful designatories. Next, we see no decision in the legislature on the conduct of judges. No decision can take place in the parliament regarding any conduct of any of the judges of the Supreme Court. That means the parliament is not going to decide the working, the actions, the decisions of any of the judge, and that is why, as they are not even deciding or discussing about that, so they cannot even take decisions whether he or she or that particular person can be removed, or any action can be taken, should be taken against him or her or not. Next, we see prohibition of practice after retirement. This is one important requisite, and that is the judge are paid a very handsome amount of pension, and that is after the retirement they do not have to work anywhere. So for that reason they are given a particular pension. Obviously they can go to any particular court, lower court, not in the higher courts, but the lower courts, and there they can pass on a judgment, but that judgment is going to be passed, or their particular visit and decision making over there will be all voluntary, as well as without any fees, without any money. It will be an honorary thing that they go there and help out in decision making or in particular judgment and jurisdiction, but they are not going to go there and charge fees for that, because they are already being given a pension for whatever the work and designation they had been holding. Now anything that they do after the retirement will be just honorary, as coming from an experienced and a learned person, so just a use of that experience, but not the use but not the for the reason, but not for the purpose of having a particular job or particular money thing. So these are the things that make judiciary totally different and separate from the executive and the legislative. Next, we have the jurisdiction and powers of the Supreme Court. Doing this, the thing you might have done, if this your chapter you have done earlier in the junior some previous classes, you will remember there are two important ways the Supreme Court works, or maybe most of the court works, and that is the original jurisdiction and the appellate jurisdiction. Here we are going to do the same thing in this particular powers of the Supreme Court. First, we have the original jurisdiction. Original jurisdiction means the first hand jurisdiction, where a case has directly come to the Supreme Court. So Supreme Court can give a decision on that, and after that, obviously we know Supreme Court is the highest authority. So after the decision is given by the Supreme Court, nobody can challenge it, nobody can take it any further higher. So in that case, and taking it lower down makes no sense. When the higher court has given a particular decision, lower court has no authority to change that decision, so it cannot go higher, lower, anywhere. Whatever the decision is given in the Supreme Court, in that instance it gets finalized. So here we see what all are the matters in which original jurisdiction can be done. First of all, when there are disputes and cases related to center and state or between two different states. So in that case, in those disputes, straight away, if supposingly Uttar Pradesh and Uttarakhand have a particular dispute over the electricity power connections and things, that is not going to be heard in Uttarakhand High Court or Uttar Pradesh High Court, because the other state will obviously blame that this state is using their High Court and that is why the decision is going to be in their favor. So in that case, it will be taken to the Delhi High Court or maybe some other state High Court, where it will be equal and neutral for both the states, and there it can be decided. But having that might also get some influence, because the High Court has no authority to give decisions to other two states, so that becomes little not up to the mark. So in that case, we can say the high courts of Uttarakhand and Uttar Pradesh will decide that okay, it is better we go to a higher authority, and that is only one single court in the entire country, and that is the Supreme Court, which is in Delhi. And then the Supreme Court will give the judgment regarding the power connection, supplies, everything, and that will be applicable to both the states. So the high courts of Uttarakhand and Uttar Pradesh will have to follow that, and that will be applicable to both the states. So center and state relationships, they're like supposingly Maharashtra has some particular problem regarding the labor force, and they have this with the union government, the central government, and in that case they have some particular disputes. So it will be taken to the high court, Supreme Court, and there the Supreme Court will give the judgment. That is what I said, Supreme Court, the judiciary has the power to pass on a judgment against anyone. They can even pass a judgment against the central government, the government itself we say, and the state government of Maharashtra. So in both the cases, both the governments will have to follow it, the central government also as well as the Maharashtra government also, if there is a dispute. This is an example, okay. Next we see when these disputes are between Government of India and one state, between Government of India and any state or states on one side, and one or more states on the other side. Then besides that, when there are two or more states at conflict with each other. So in these cases, the case can directly be taken to the Supreme Court. Now the jurisdiction, there are certain exceptions. When a dispute arising out of treaty or agreement which is in operation, the treaty is still going on, and still when the treaty is going on, you cannot raise a dispute on it and take it to the court. When it gets over, then only it will be taken to the court. In certain other matters such as interstate water disputes, matter referred to Finance Commission, that has to be decided among themselves with their interpersonal relationships. And then adjustment of certain expenses and pensions between union and the state governments. Besides that, other reasons, you can say other types of cases which can directly be taken to the Supreme Court are all the cases which are related to the fundamental rights and the protection of the fundamental rights. It can be of a group, of a firm, of a community, or of an individual. They can be taken to the Supreme Court, and that is how Supreme Court will pass on a judgment for the protection of the fundamental rights of that group, that sect, that particular firm, or that particular company, or maybe that particular entire people of that region. So accordingly, fundamental rights protection can be taken to the Supreme Court directly. Transfer of cases from the lower courts. Here we see, you will say this is basically an interpellation, but here we see, I'm reading it for you so that you get a better understanding. Under Article 139A, inserted by the 44th Amendment Act in 1978, Supreme Court may transfer to itself cases from one or more high courts if these involve questions of law or cases are of great importance. सो ऐसा नहीं है कि वो जो केसेस आते हैं सारे के सारे ऊपर हाई सुप्रीम कोर्ट में, दे आर ऑल appellate jurisdiction. Some of the cases are transferred from the lower courts to the higher court, but these cases are not transferred by people or by the courts. It is basically transferred or taken by Supreme Court itself, and that is because they think that the lower court does not have that much authority to give a decision or pass a decision on that particular issue, which requires some new law to be made or some particular importance of for the entire nation. So in that case, the case will be taken to the Supreme Court. Next, we see interpretation of constitution. All cases where interpretation of constitution is required can be directly filed by the Supreme Court. So those cases where a new particular kind of case has been filed, or the case is totally different and a new in nature, and a new law can be issued, or maybe or should be issued for that particular case. So in that case, obviously a high court or a lower court will never be making a new law. It will be only by the consent of the Supreme Court that a new law or an amendment in the law or a constitution will be done. So in that case, all such cases where amendment and some changes in the constitution or law has to be made, they are all taken by the Supreme Court. Next, we move on to the appellate jurisdiction. Appellate jurisdiction are basically called as the second-hand judgment. Why is it called a second-hand judgment? Because these are the cases which have already been heard in the lower court, maybe the high court or the other district courts and the lower courts, and from there it has passed on higher to the Supreme Court. And so high court has passed on to the Supreme Court for certain reasons. First of all, it requires some important judgment to be seen by the Supreme Court only, or maybe you can say it is beyond the powers of this high court. So for such reasons, high court has passed on that case to the Supreme Court. Now, what are the cases that can be heard over here in appellate jurisdiction? That we'll see. They are also called cases for cases of appeal. So here first we have the constitutional cases. All matters irrespective of nature, whether where a certificate is issued by a high court that it involves an important point of law and needs interpretation of the constitution. Now, as I told you, interpretation of constitution, wherever it is required, Supreme Court takes that particular judgment or case to its custody. But here many a times they might not even come to know about that. So in that case, a high court might say that this case is beyond our particular jurisdiction, and that is why high court itself can pass on that particular case to the Supreme Court. Then it will be an interpretation of the of the law, and it will be taken by the Supreme Court under that heading. Next is civil cases. Appeals in civil matters lie to the Supreme Court. Civil cases means of higher importance, and that is in the high court they have already been heard, but they were not given proper judgment, or some particular party or group on the opposition were not happy from the opposition, any of the groups. So they disputing groups, sorry. So any of them can put up a file about that case in a higher court. That means high court se upar in the Supreme Court. So then it will be taken over by the Supreme Court in the appellate jurisdiction. It is that if only taken if the case involves a substantial question of law, and that is of general importance for most of the people, or similar cases, or otherwise that the question needs to be decided by the Supreme Court, or they are not satisfied with the judgment of the High Court and they require Supreme Court to pass on a judgment on that and a special decision to be taken. Next, we see the criminal cases. When we talk about the criminal cases, two types of appeals in the criminal cases can be seen. Cases without a certificate of the High Court and cases with the certificate of the High Court. That means in some places, some cases, High Court is saying that the decision in such a case should be given only by the Supreme Court, because they think that the crime is of a very grave, serious nature, and that should be looked only by the Supreme Court. But in other cases, High Court might not even consider that it should be taken to the Supreme Court. They might have given a judgment, but people think that we are not satisfied, they have not given us a proper judgment, and then the people might take it to the High Court, Supreme Court. So in that case, again it will be taken by the Supreme Court as an appellate jurisdiction. So these are the two broad powers, we can say, in judgment decision making or judgment passing by the Supreme Court, and that is appellate jurisdiction and the original jurisdiction. So powers, basically these are the main works, the way the Supreme Court works, but we have taken it as powers. Now in the next video we will be doing the functions of the Supreme Court. In the functions of the Supreme Court, the first two functions I will not do with you, because that will just waste our time, because they are original jurisdiction and the appellate jurisdiction. We have already done in the powers. So these first two powers original jurisdiction की power and appellate jurisdiction की power. These two are your basically two functions, also two important functions of Supreme Court also. So in the next video we will start the functions of video by just naming these two, and then moving on to the third one, that is enforcement of law, and then the advisory functions and so on. In your book you can even check page 204 if you have the same edition or somewhere similar, under the heading functions of the Supreme Court. So first is settlement of disputes, original and on appeal. That we are not going to do. We will move on from the enforcement of fundamental rights. But for today, go through this video and read out the chapter pages which we have covered in this particular video. So with this we come to the end of the video.